An article that came out in DJ Supra, October 11th, 2018. Weeding out a job candidate, literally, Connecticut court weighs in on medical marijuana laws and drug tests. What do you do with employees who use legal marijuana in violation of your drug-free workplace policy? So far, 30 states and the District of Columbia have enacted laws permitting use of marijuana for medical purposes, and 8 states and the District of Columbia has legalized recreational use. Several other states are currently considering similar legislation. As marijuana use become increasingly permissible under state law, but remain illegal under federal law, many employers are left wondering how to enforce their existing drug testing and drug-free workplace policies. Can you apply your no-tolerance drug policy to a medical marijuana user, not according to one federal court in Connecticut? Interesting. Connecticut's law prohibits employers from terminating or refusing to hire a person solely based on of that person's status as a qualifying patient who uses medical marijuana. Noffsinger versus SSC. Okay, so look like there was a court case and a person failed a pre-employment test by the name of Caitlin Noffsinger, and she was using the marijuana for medical purposes. Okay, so Miss Noffsinger accepted SSC's job offer, but the offer was contingent on her passing a drug test. Before she took the drug test, Ms. Noffsinger disclosed that she suffered from PTSD and that she was a registered participant in Connecticut's medical marijuana program to treat it. She informed SSC that she used medical marijuana in the evenings, not during work hours. She even showed SSC a copy of her registration certificate required by the law and an empty pill container that showed the name and dose information of her marijuana pills. Unsurprisingly, her drug screens was positive for marijuana, and SSC rescinded her job offer. Ms. Noffsinger sued for violation of the Connecticut law, and SSC removed the case to federal court. SSC asserted that the positive drug test disqualified Ms. Noffsinger for the job because SSC, a federal contractor, adopted a drug testing policy that followed the federal law, and medical marijuana is not an approved prescription under the drug testing program. In the defense, SSC emphasized that as a federal contractor, it was required to follow the Federal Drug-Free Workplace Act, and that the federal act preempted the Connecticut state law. The court rejected this argument, noting that the federal law requires federal contractors to make a good faith effort to maintain a drug-free workplace, but it does not require a zero-tolerance drug testing policy, such as SSC's policy. Instead, the court held that the federal law is focused on preventing use of the drug in the workplace, not use of any drug outside of the workplace. much less the use of medical marijuana, which I agree. If she wasn't doing it in the workplace and it is medical and it was prescribed to her, then no, they shouldn't be doing anything to her at that point. You're aware that she's going to come up positive because she's using medical marijuana. I mean, that's a no-brainer. SSC argued that the Connecticut law only protects against discrimination based on a person's status as a medical marijuana user, not their actual use of the drug. Given that SSC did not rescind Mrs. Noffsinger's job offer when she disclosed her status as a participant in the medical marijuana program, they're saying that she failed their standard pre-employment drug test. Well, she would if she's taking medical marijuana. Again, a no-brainer. SSC argued that it did not base the decision on her status. The court said this argument made no sense and would frustrate the purpose of the state's law anti-discrimination provision to protect people who use medical marijuana from adverse action by their employers. For employers in this case is a reminder to beware of any local or state laws regarding medical or recreational marijuana use that may apply to your employees. If you aren't sure whether your state has legalized marijuana in some form, do some research. Although not every court is going to agree with this Connecticut decision, don't assume that relying on federal law or continuing to enforce the drug testing policy you've always used will avoid liability. So there you have it. In this woman's case, the court sided with her and not SSC, the company that she was applying for a job with. But real interesting, you know. First of all, they need to do something about the laws. That way they are consistent. Right now, there's too many inconsistencies in the laws when it comes down to marijuana, and that's why all of this confusion is going on in the first place. But please tell me what you think, ladies and gentlemen. Please leave your comment and subscribe. Don't forget to hit on the notification bell, and I'll see you on the next video. Peace, family.